Classroom control and learning efficiency are products of good teaching. Learning must be made meaningful. Interest in work for which learners see a purpose provides its own discipline.
My name is TLewis, and this is my partner. KwanzaB. Strict criticism refers to political, legal, philosophy, and judicial interpretation that limits or restricts judicial interpretation. Requires a judge to apply text only as is spoken. Once that the court has cleared meaning of the text, no further investigation is required. Judges should avoid or draw inference from a statute or constitution and focus only on the text itself. Strict criticism is also used in American political discourse as an umbrella term for conservative legal and philosophy, such as original and text, which emphasize judicial restraint and fidelity to the original meaning and constitution and laws. Strict criticism, Congress should allow the exercise very few implied powers so that government will remain small. Board criticism, Congress should be allowed to excuse many implied powers that the government can take a greater role in shaping events. Americans have disagreed about this since the beginning. Jefferson is the leader of the strict criticism, and Hamilton is of the board. It has been the first major political dispute in U.S. history.
We have two different kind of people in our court system. You have liberal and conservative people. There's a difference between liberal and conservative people. Liberal people believe the individual collective responsible for the welfare and the entire community, and conservatives believe the individual are responsible for themselves and that the community benefits from an effort individual activity and the interest. Now there are 9 judicials in our court system. The shifting on our political balance of the court system changes basically due to who the president is. Once someone dies, the president picks up who he wants to place the judicial that passed. Due to that advantage, if the president is liberal or conservative, either which one he is, he thinks should be in the judicial. We have 9 people in our court system. 5 are conservative and 4 are liberal. For example, our President Obama is liberal, so due to that fact that he is liberal, and the advantage of that is that whoever dies in the court system, he picks up who he wants, which he will want people to think how he would think. So of course he's going to pick someone that's liberal. Not to mention that the people in the Supreme Court is not always minded up on whether they want to be. They can be liberal or conservative. Their minds are not always made up. They change over time.
Keep talking.
The shift in political balance of our court system changes due to the people and also who the president may be.
You hear me? Understand? We already got this.
Start with a trial court of original general jurisdiction. It's where you file tort for contract civil claims, criminal prosecutions, housing sessions, and small claims. Sometimes family cases where jurisdiction is the same. But don't forget the courts of limited jurisdiction, where state law grants them power to proclaim. It's a matter of jurisdiction, the power to speak the law. It's jurisdiction that matters after all. Back in the trial court, you have an opportunity to be heard. You'll get worthwhile support from your lawyer if you're wise, examining your witnesses, exposing opposing witness lies, placing documents in evidence, fending off the other side. It's the adversarial system on display and in the flesh, hoping to just result, the court will rise. It's a matter of jurisdiction, the power to speak the law. It's jurisdiction that matters after all. You have a right to appeal the trial court result if your attorney feels there have been errors of the law. With appellate jurisdiction, the court will examine the claim flaws, but won't conduct a trial, just legal argument, that's all. And remand the case if needed back to the trial court once more, if needed to reverse the errors of law. It's a matter of jurisdiction, the power to speak the law. It's jurisdiction that matters after all. What of the Supreme Court, the highest court in the land, the court of last resort? In any state may bear a different name. Settling the law is usually the aim, and in most cases the procedure is the same. You may petition, but the court's docket is its own, and they may not choose to hear your claim. It's a matter of jurisdiction, the power to speak the law. It's jurisdiction that matters